Hello guys, welcome back to my channel. It is Debs. I'm a paralegal here today to review this detention memo regarding Sean or P. Diddy, as we know him. So I'm sure you probably heard. He's in jail now, I guess, regarding sex trafficking amongst other things. So yeah, trigger warning, I guess, if that's a trigger for you. But yeah, I just wanted to review this and kind of just delve deeper because I know I've known him since the 90s. I don't know when he first came around, so this is pretty wild. And he really did a pretty good job of flying under the radar, at least as far as I know. So this is pretty wild, and it also kind of makes me think of what else is, or who else flies under the radar. So I guess, let's just get into it. So on September 17th, 2024, an indictment returned by a federal grand jury sitting in the Southern District of New York was unsealed, charging the defendant with racketeering conspiracy from in or about 2008 through on or about the date of the indictment in violation of 18 U.S.C., sex trafficking from in or about 2009 through in or about 2018 in violation of 18 U.S.C. 1 and 2, and interstate transportation to engage in prostitution from in or about 2009 through in or about 2024. Combs' use of violence, threats, and coercion. Since at least 2008, defendant and other members and associates alleged in the indictment, including his multifaceted business empire, which is the Combs business, wielded the power and prestige of the defendant's reputation as a musician, entrepreneur, and figure in the entertainment industry to commit federal crimes, including racketeering, sex trafficking, and other offenses. Many of these crimes involve the sexual abuse and exploitation of women and other crimes of violence. Part 1, regarding sex trafficking and abuse. Using the power and prestige of the enterprise, the defendant lured female victims into the defendant's orbit, often under the pretense of a romantic relationship. The defendant then used force, threats of force, and coercion to cause these female victims to engage in sexual activity, which included frequent sex acts with male commercial sex workers that the defendant referred to as freak-offs. Freak-offs were elaborate sex performances that the defendant arranged, directed, masturbated during, and often electronically recorded. Freak-offs occurred regularly from at least in or around 2009 through this year, sometimes lasting multiple days, and frequently involving multiple sex workers. The defendant arranged freak-offs with the assistance of members and associates of the enterprise, including employees of his business, and the hotel rooms where they were staged often sustained significant damages. One thing I will say that I have heard rumors about certain celebrities, rappers particularly, that do have these kind of like after parties, like at their place, you sign an NDA. I mean, I haven't really heard in-depth stories, but I always thought that was like suspicious. So that is a thing that happens. So it's scary to think that like how dark those things could potentially get. In fact, you do sometimes hear rumblings of allegations, even about influencers and things like that. But they make people sign NDAs and things. But to be honest, if they're committing a crime, an NDA doesn't matter. So just so you know. Oh, but yeah, that's scary. Okay, the defendant ensured the victims would participate in freak-offs through coercion and violence. For instance, they provide controlled substances, including ketamine, ecstasy, and GHB to female victims so they could and would continue to engage in freak-offs despite fatigue, physical and emotional exhaustion, and pain. Additionally, both during freak-offs and separate from freak-offs, the defendant subjected female victims to physical, emotional, and verbal abuse, in part to cause them to engage in freak-offs. The defendant hit, kicked, threw objects at, and dragged female victims, sometimes by their hair. At least a dozen witnesses will confirm that they personally observed the defendant's violence towards women and or the injury sustained by women at the defendant's hand. One incident of physical abuse occurred when a female victim was attempting to leave the hotel following a March 2016 freak-off. This abuse was captured on video surveillance and publicly reported in May 2024. The defendant's assaults often resulted in serious injuries to the victim that took days or weeks to heal, which, if I'm not mistaken, I think is Cassie, his ex-girlfriend. And also, like, shout out to her because of her coming forward. Like, this stuff started to more things started to come out, so she's really brave for that. The defendant also coerced victims into participating in freak-offs by controlling their careers, finances, livelihood, and/or housing, among other aspects of their lives, or by threatening to disseminate recordings of freak-offs. The defendant used his considerable wealth and influence to make victims rely on him financially, for example, by paying for their rent or their cars, or by offering them career opportunities. Once he provided his support, the defendant repeatedly threatened to take it away to ensure the victim's compliance with his demands, including their participation in freak-offs. Indeed, victims believed that they cannot refuse the defendant's demands that they engage in freak-offs without risking their financial security or career prospects, or without repercussions in form of physical or emotional abuse. In addition to the defendant's physical, sexual, and emotional abuse of his romantic partners, the defendant repeatedly engaged in acts of violence towards his employees and others. As charged in the indictment, the defendant, often assisted by members and associates of the enterprise, engaged in kidnapping, arson, and physical violence, such as throwing objects at people, throwing people to the ground, and hitting, dragging, choking, and shoving others. Numerous witnesses, including the defendant's employees and others, observed or experienced violence from the defendant firsthand and sustained lasting trauma as a result. And I know I was young at the time, but I think in the 90s he was kind of, if I remember correctly, part of like that first wave of rappers that really took off, like Biggie and Tupac, for example. And I think during that time, like, it was legit, like they were, slanging things, and so they probably do come from, gangster background, where I know that I'm sure there are some that nowadays are, but it's kind of not so much that. But I think back then it was pretty legit, so I don't know what his background is, but it seemed like some of the rappers from around that time maybe came from that background, and some of those rappers unfortunately didn't make it till today, like Biggie and Tupac, for example. Like, there's a lot of, I don't know the lore of it, like, deep down, but just something to note, I guess. For example, in the early morning hours of December 22nd, 2011, the defendant and a co-conspirator kidnapped an individual at gunpoint to facilitate breaking into and entering the residence of another. Multiple witnesses would testify at trial to the events surrounding the kidnapping and break-in, the latter of which is corroborated by police reports and other records. Approximately 2 weeks later, defendant's co-conspirator set fire to individual one's vehicle by slicing open the car's convertible top and dropping a Molotov cocktail inside the interior. Police and fire departments reports extensively document the arson and conclude that the fire was intentionally set. Multiple witnesses would also testify to the defendant bragging about his role in destroying the individual's car. More broadly, since at least 2008, allegations of the defendant's physical abuse of women and others have been publicly reported in the media, including in Hollywood blogs and podcasts. Law enforcement reports corroborate that police responded to several instances of the defendant's violence, including assaults against victims and other individuals. More recently, there has been an outpouring of other public allegations against the defendant, including claims of threats and physical and sexual violence dating as far back as the 1990s. In short, the defendant's violent tendencies are widely known. However, at no point during the past few decades has the threat of public exposure or law enforcement intervention deterred the defendant from continuing his abuse. Wasn't there some kind of allegations about him at a club, something to do with Jennifer Lopez? I can't remember, but there's been definitely like rumors or stirring about him. But okay, let's go on. Firearms. The defendant and members of the enterprise, including the defendant's security personnel, at times carried firearms, and the defendant himself carried and brandished firearms to intimidate and threaten others. Indeed, some victims were aware of the defendant's access to firearms. On one occasion, the defendant forced a female victim to carry a firearm on his behalf, and on another, pointed a firearm at a female victim. The defendant continues to have access to guns, including illegal firearms. In March 2024, during searches of the defendant's residences in Miami, Florida, and Los Angeles, California, law enforcement seized firearms and ammunition, including 3 AR-15s, each with defaced serial numbers, as well as large-capacity drum machine. Wow, so he didn't want them to be, traced back to him, I guess. So that's obviously up to no good. Also, like, why would you need something like that? Oh, God, that's so fucked up. Okay, as pictured below, a serial number is visibly bored through and obscured so that it couldn't be, like, tied back to whoever, I guess, bought it on paper. 2 of the 3 defaced AR-15s were found in the defendant's Miami bedroom closet, stored broken down in parts, along with magazines that were loaded with ammunition, as depicted below. One of the AR-15s had a 10-round magazine loaded with 10 rounds of large caliber ammunition, while the other one had a 30-round loaded with 19 rounds. A large capacity drum machine loaded with 59 rounds was seized from his residence. Holy, what the fuck are you trying to do with that? That's insane. In addition, 6 legally purchased guns with serial numbers, some of which were stored in gun safes, were recovered from the defendant's residences. Although these particular guns, both the legal and illegal firearms, were seized, their presence in the defendant's homes demonstrates that the defendant has access to and surrounds himself with both guns and ammunition. Likewise, even if the defendant were personally restrained by the court from obtaining new firearms himself, he could retain access to them through others. And also, if he's, like, obviously removing the serial numbers or whatever, like, he obviously knows how to get it without having, like, a paper trail. So he wouldn't give a shit if they're just don't get new guns. He'll be like, okay, how has he been getting them this far? Pretty sure he didn't go down to the Walmart and get that, that's for sure. In sum, the defendant's regular use of violence and threats of violence, as well as coercion described above against victims and others, fostered a culture of fear in which these individuals believed they were unable to reject the defendant's demands without subjecting themselves to physical violence or other abuse. Combs bribed witnesses and obstructed justice. Throughout the time period charged in the indictment, when the defendant faced the possibility that his violent and criminal conduct could become public, the defendant and other members and associates of the enterprise pressured witnesses and victims not to report what they saw or heard to law enforcement or to otherwise conceal the criminal conduct. For example, and as noted above, in March 2016, the defendant was captured on video surveillance striking, kicking, and dragging a woman in a public area of a hotel in an apparent attempt to prevent her from leaving a freak-off. When a member of hotel security staff intervened, the defendant attempted to offer the hotel security officer a stack of cash to ensure his silence. After the security guard refused the defendant's bribe, and after coordination between the defendant and his employees, the defendant's staff contacted other members of hotel security. At the same time, staff members were in close communication with the victim of the assault as well, all in an effort to cover up the defendant's assault and to prevent the incident from being publicly disclosed. Within days of the incident, the surveillance video disappeared from the hotel server. Oh, that's so fucked. Similarly, throughout the time period charged in the indictment, members and associates of the enterprise have reached out to multiple victims on behalf of the defendant to convince them not to report the defendant's abuse. Most recently, in late 2023, immediately following public allegations of certain of the defendant's crimes, including his physical and sexual abuse of women, the defendant and other members of the enterprise made repeated phone calls to victims and witnesses, during which they provided victims and witnesses with false narratives of events in an apparent effort to conceal the defendant's crimes. On at least 2 occasions, the defendant recorded those calls on a co-conspirator's cell phone, thereby attempting to obscure his involvement in the obstruction. The government's investigation is ongoing. While the indictment against the defendant was unsealed today, the investigation into his and other co-conspirators' conduct is active and ongoing. So, I mean, obviously, there's more to it. I wonder, it's probably going to maybe be like a Jeffrey Epstein kind of situation. I think we might even still be waiting to this day to find out, like, really who used that. But I wonder, is it going to be something similar to that? I wonder how deep this goes. But yeah, let's continue. As a result of that ongoing investigation, as well as the defendant's charged conduct outlined above, including obstruction of justice and witness tampering, the government is limited in its ability to fully set forth all known details of the defendant's criminal conduct, including details of certain witness testimony. Yeah, of course, because you don't want to put all your cards out on the table. Save it for the trial, I guess. To the extent the court has additional questions about the charged offense conduct or any other information set forth herein, the government is prepared to proffer additional information on ex parte basis. Also, I would not be surprised if they, like, somehow obviously like find out any other people involved. I would be surprised if they try to make plea deals with those people, because it sounds like he's the big fish in the sea. And I mean, they must have like enough on him to have. I mean, it's one thing you can put them in jail, but you never know. Like, they sometimes even on like a technicality, they can get the whole case can be let go. Like if they didn't have a warrant or a proper warrant or something like that, on a technicality sometimes. So, but I'm sure they probably like had to build it to such like a big extent to begin with. But it'll be interesting to see, like, who knows, maybe they already made those deals and that's how they were able to catch him. Yeah, you know what? That's probably makes more sense, to be honest. They probably already made those deals, and they probably don't want to reveal who made the deals. But yeah. Applicable law. Under Bail Reform Act, federal courts are empowered to order a defendant's detention pending trial upon a determination that the defendant is either a danger to the community or a risk of flight. A finding of risk of flight must be supported by preponderance of the evidence. So, a finding of dangerousness must be supported by clear and convincing evidence. So, I think it would have to be like pretty clear cut to be like no bail, and to like, yeah, to basically keep them in jail until like before their trial. It has to be like quite a large amount of evidence and proof that they're a danger to others. And it says obstruction of justice is another ground for pretrial detention by the courts. Yeah, that's a fair point too, like, because if he was able to not be in jail waiting for the trial, and he has a history of obstructing justice, that would give him the time and the ability to, do whatever it is that he does to obstruct justice, maybe kill off witnesses, or, you know what I mean? If that makes sense. Obviously, it depends who he has on the outside, but it's a lot easier when you're on the outside. It says courts in the Second Circuit have held that pretrial detention for obstruction of justice is appropriate as long as the government can establish by clear and convincing evidence that there exists a serious risk the defendant would threaten, injure, or intimidate a prospective witness or juror. Yeah, just as I said, yeah. Danger to the community, essentially. Bail Reform Act lists 4 factors to be considered in detention analysis: nature and circumstances of crimes, including whether offense is a violation of Section 159(1), the weight of the evidence against the person, the history and characteristics of the defendant, including the person's character, past conduct, and financial resources, and the nature and seriousness of the danger to any person or the community that would be posed by the person's release. The concept of dangerousness encompasses not only the effect of a defendant's release on the safety of identifiable individuals such as victims and witnesses, but also the danger that the defendant might engage in criminal activity to the detriment of the community. A finding of dangerousness does not require that the defendant have criminal history, particularly if a defendant has a history of domestic violence. prior acts of domestic violence are relevant to a determination of dangerousness, because their willingness to strike loved ones offers probative evidence of tendency to violence and dangerousness towards others. Evidentiary rules do not apply at detention hearings. Government is entitled to present evidence by way of proffer. Where a judicial officer concludes after a hearing that no condition or combination of conditions will reasonably assure the appearance of the person as required and the safety of any other person and the community, such a judicial officer shall order the detention of the person before trial. Additionally, whereas here a defendant is charged with sex trafficking in violation of 18 U.S.C. 1951, in other words, an offense under Chapter 77 of Title 18, it shall be presumed, subject to rebuttal, that no condition or combination of conditions will reasonably assure the appearance of the defendant as required and the safety of the community. Discussion. For the reasons set forth below, defendant poses a significant danger to the community, both in terms of physical violence and obstructive conduct, as well as a risk of flight. This is especially true given the nature of the criminal conduct and the strong weight of the evidence. The defendant, therefore, cannot overcome the statutory presumption in favor of detention in this case. Dangerousness. The defendant is charged with serious and violent crimes. As charged in the indictment, defendant has physically and sexually abused women and others. So I guess all genders, are for the better part of 2 decades. The sex trafficking charge, based on the defendant's abusive conduct, carries with it a presumption of detention. And detention is particularly supported by the facts of this case. Since at least 2008, the defendant has engaged in serious acts of violence, including forcing and coercing women to participate in sexual activity, including acts with commercial sex workers by using physical force, financial pressure, emotional abuse, and narcotics. These acts, described in detail above, were referred to as freak-offs, among other names, and involved orchestrated sexual performances facilitated through drug use that sometimes lasted days at a time. I really hope that any victims that don't want their name or their experience made public, I really hope that they don't make it public. Especially if it's like, if they're a man or something. And obviously it sucks for all genders, but in general, I hope they don't reveal if they don't want it revealed. But anyway, that is not all. As set forth in the indictment, the charges against the defendant capture significant additional violence, both spontaneous and premeditated. On numerous occasions, the defendant assaulted women, employees, and others when he became enraged by throwing objects at them, choking them, pushing them, kicking them, and slamming against walls and onto the ground. Defendant and other members and associates of the enterprise were also capable of premeditated violence, resorting to kidnapping and arson when the defendant's power and control were threatened. The defendant's violence, whether spontaneous or premeditated, had the effect of exerting his continued control over these individuals. The defendant also carried firearms to intimidate and threaten others. Multiple defaced semi-automatic rifles were recovered when law enforcement searched the defendant's residences in March 2024, including 2 defaced rifles that had been disassembled and hidden in the defendant's bedroom closet. In short, the conduct with which the defendant is charged shows a pattern of violent and abusive conduct, underscoring his dangerousness. Sorry, one sec. This disposition to violence cannot be reasonably prevented through bail conditions. The violence alleged in the indictment was not isolated or aberrational. It was systematic and pervasive. The defendant abused women with whom he was in personal relationships, employees, witnesses to his crimes, and others. As described above, the defendant has sexually, physically, and emotionally abused long-term romantic partners for decades, including by forcing them to engage in freak-offs. The defendant has abused countless others in his orbit, and in particular women, without regard for consequences. Indeed, the defendant's abuse of power long predates the conduct charged in the indictment. To date, at least 5 women have publicly accused the defendant of violent sexual assaults back to the 1990s. Moreover, the defendant's violence and abuse often occurred behind closed doors, including in his homes, hotels where he was staying, and other private settings. He has assaulted victims, employees, and others, and even brandished a firearm at a victim in his homes. The alleged sex trafficking similarly took place in private settings not easily monitored. Indeed, in addition to engaging in freak-offs at hotels, the defendant has, at times, organized freak-offs at his home or at the homes of his female victims. This is precisely the kind of violence that even strict conditions such as home incarceration cannot prevent. In sum, the defendant's long history of violent conduct makes clear that even the most stringent bail conditions will not suffice to ensure safety of the community. The defendant is a serial abuser who repeatedly assaults and coerces women to achieve his own sexual gratification, and uses his vast wealth and position of power in the entertainment industry to conceal his illegal conduct and prevent victims of and witnesses to his abuse from coming forward. The defendant's long-standing pattern of abuse is probative evidence of the likelihood that he will continue to abuse. Indeed, nothing, not even the threat of public exposure or law enforcement intervention, has stopped his abuse. The defendant has continued to physically assault and threaten those around him, including his romantic partners, his employees, and others who happened to be present when he succumbed to fits of rage. No bail conditions can address the defendant's tendency to become violent when angry or emotional. Anyone in his presence is at risk of abuse or assault, and the defendant's physical assaults are serious, resulting at times in serious injury requiring medical intervention and long periods of recovery. Therefore, the nature and seriousness of the danger to any person is both real and specific. Obstruction. As part of the charged racketeering conspiracy, the defendant engaged in obstruction of justice, including bribery and witness tampering. Given the defendant's history of engaging in obstructive conduct to conceal his criminal activity, both personally and through intermediaries, there is every reason to believe that he will continue to engage in such obstruction if released. As detailed in the indictment, following a freak-off in March 2016, the defendant attempted to bribe hotel security staff to prevent hotel security from publicly disclosing and/or reporting to law enforcement his vicious attack on a woman attempting to leave a freak-off. The defendant's efforts to disclaim responsibility for that attack continued until earlier this year. A civil lawsuit was filed on or about November 16, 2023, alleging years of sexual, emotional, verbal, and physical abuse by the defendant, including allegations describing the March 2016 incident. Following the filing of the lawsuit, the defendant stated in no uncertain terms, "Let me be absolutely clear, I did not do any of the awful things being alleged." I never reviewed Cassie's lawsuit. I mean, I'm assuming it was Cassie. But I know that, or at least from what I heard, that he was really quick to settle it. But I guess once she filed it, it became public knowledge. And I think she was obviously very brave for doing that. And because of that, more things or more people got the courage to come forward as well. So, well, you're an amazing, brave, powerful woman, Cassie. Whew. Wow. I'm so proud of her. So, through counsel, the defendant vehemently denied offensive and outrageous allegations, describing the complaint as riddled with baseless and outrageous lies. It was not until the video surveillance where the defendant's attack was leaked to the media months later that the defendant was forced to admit that he had, in fact, perpetrated the disgusting attack. Clearly, the defendant is willing to deflect, minimize, and lie, and induce others to do so on his behalf to avoid taking responsibility for his own actions. More recently, the defendant has, directly and through intermediaries, engaged in obstructive conduct related to the matters under investigation in this case, specifically following the November 2023 lawsuit. The defendant and intermediaries acting on his behalf reached out to potential victims and witnesses to the alleged conduct, including individuals he did not speak to regularly and had not spoken to in years, to attempt to feed those victims and witnesses false narratives about the defendant's criminal conduct. With respect to at least two of these individuals, the defendant's co-conspirators assisted in efforts to protect the defendant. For example, on or about November 19th, 2023, just 3 days after the filing of the lawsuit described above, the defendant made multiple calls to another victim of his sexual abuse and recorded certain of those calls using the cell phone of a co-conspirator. During the calls, the defendant repeatedly asked for the victim's support and friendship and attempted to convince the victim that she had willingly engaged in acts constituting sexual abuse. The defendant also assured the victim that if she needed the defendant to, she ain't got worry about anything else. A thinly veiled attempt to coerce the victim into adopting and supporting the defendant's false version of events to protect the defendant. Even more concerning, since learning about the criminal investigation, including following the execution of the search warrants at his residences, Combs contacted other witnesses on multiple occasions, including other witnesses who had received grand jury subpoenas. The defendant's recent conduct is similar to that in United States versus LaFontaine, in which the Second Circuit affirmed the district court's revocation of pretrial release after the defendant in that case engaged in witness tampering. Specifically, the defendant, who was charged with multiple counts of fraud in connection with providing false claims to medical insurers, called a witness to remind the witness that a particular patient had received surgeries that the patient had not, in fact, received. The Second Circuit affirmed the district court's finding that there is no condition or combination of conditions that would assure the safety of the community given the defendant's witness tampering, despite the fact that the defendant's tampering did not include actual violence or threats of violence, but there is obviously violence and threats of in this case. In rejecting the defendant's arguments, the district court's finding of dangerousness was not justifiable. The Second Circuit noted that the defendant had fed the witness false testimony with the expectation that the witness would adopt it, and even stringent electronic monitoring conditions could be circumvented. Here, the defendant's conduct goes beyond what the LaFontaine court found sufficient to revoke bail. That's for sure. Even before being charged with the crime, the defendant has taken numerous proactive steps to tamper with potential witnesses' testimony against him. There must be like a leak or something then. If he must be getting like, he must be finding out somehow that they're onto him, or like, so he can, if he's able to get ahead of it, there's got to be someone like, whether it's the police or, they got to be, that's the only way. Which would also explain why it took them so long. Apparently they're saying since like the 2000s or something, or they've been trying to build this case against him. The government is aware through electronic evidence, toll records, conversations with witnesses, and other evidence that the defendant has contacted witnesses, including subpoenaed witnesses, prior to the dates on which the witnesses were required to appear before the grand jury. In addition, the defendant has recorded calls with at least one victim and provided, either directly or through intermediaries, false narratives of the events that transpired, so that those witnesses would adopt that false testimony. Moreover, the defendant's obstructive conduct is made even more alarming by the manner in which he carried it out to evade detection, in some instances by having intermediaries make calls on his behalf and recording certain calls on another individual's device. These deliberate actions show that the defendant was aware that what he was doing was obstructive and that his aim was to avoid detection. Even the most stringent conditions, including the monitoring of a court-authorized electronic device, would fail to ensure that the defendant would not engage in this kind of obstruction from his home, including by acting through intermediaries and using others' devices. So I wonder, is it like a thing, or is it possible to make it so, like, because usually, I don't know shit about what it's like to be in jail or what the procedure is, but at least, I should, but I don't come from a criminal law background, but anyways, in the movies, I guess, people are allowed to have visitors and things like that, but I'm wondering, given his situation, would he be allowed to have visitors? I guess they could supervise it, but if he's such a risk for that, I wonder if they would not allow him to. That's it. Yeah, I wonder. But yeah. And risk of flight. Nor can the defendant overcome the presumption that he is a risk of flight. The crimes that the defendant is charged with carry significant penalties, including a mandatory minimum sentence of 15 years imprisonment and a statutory maximum sentence of life imprisonment. I don't know. The things they're alleging here is that, like, I don't know. What's the death penalty like in the States? Like, I don't know. I mean, death penalty, that's like a big can of worms, but some people are so psychopathic that the world would be a better place without them, especially if it's like without a doubt, like it's for sure that they did it, you know? The possibility of a substantial sentence is a significant factor in assessing the risk of flight. Let's see. A steeper potential sentence, more probable flight risk is, especially considering strong case of the government. And dude, he's so loaded. He's set for life. He could live. Who knows? Does he? He might even own an island. Who knows? Or just go to someone else's. I don't know. Some other creeper's island or something. He's so rich. Like, he's set for life. Here, the defendant is facing at least 15 years imprisonment if he's convicted, at least. I don't know. That seems a little bit chill for all the things that they're alleging. This fact alone would provide a compelling incentive for anyone to flee from prosecution, but the incentive to flee is especially strong for this defendant, who at age 54 faces the very real prospect of spending a substantial portion of the rest of his life in prison. As detailed below, the evidence in this case is incredibly powerful, as the facts set forth in the indictment and herein make plain. Dozens of victims and witnesses have provided detailed, credible, and corroborated information against the defendant. These individuals include many who personally experienced and witnessed violence and other crimes at the hand of the defendant. Let's see. Moreover, their accounts are well corroborated by significant intrinsic evidence, including financial and billing records, travel records, electronic data and communications, including extensive communications by and with the defendant himself. For example, victim testimony regarding freak-offs is at times corroborated by other witness testimony, communications with the defendant and commercial sex workers, travel records, hotel records, videos of the freak-offs, and records reflecting or indicating payment. Similarly, a victim's physical abuse may be corroborated by, among other things, videos of the abuse, photographs of injuries, reports made to law enforcement, communications with the defendant and others, and testimony from other witnesses who saw or heard about the abuse. The vast and varied sources of evidence described in detail below will be compelling evidence of guilt at any trial in this case. Thus, the serious risk of conviction provides further incentive for the defendant to flee prosecution. Moreover, in this case, the risk of flight is augmented by the nature of the evidence against the defendant. The evidence against the defendant, which would be made public at trial, includes substantial evidence that is highly sensitive and has the potential to significantly and negatively impact the defendant's reputation. For example, dozens of video recordings created by the defendant of freak-offs with victims, which actually I was just thinking, like, it's almost like by recording it, he's like, became evidence against him. But some psychopaths just can't help it, I guess. For decades, the defendant has spent significant time and resources ensuring that his criminal conduct avoids public scrutiny. Given the potential penalties here, both incarceration and reputational harm, the defendant has every incentive to flee to avoid prosecution and a public trial. The shame of the allegations that he is facing is also an immense incentive to flee. Something tells me that he's just truly a psychopath. And I don't think that psychopaths are capable of feeling like shame, maybe. They probably wouldn't like that people know who they are, but I highly doubt. Like, shame is almost like empathy or like guilt. I don't think. I mean, allegedly or whatever, but yeah, I'm just saying that because, in law, you always have to say allegedly, but I don't know. I'm sure they have. I haven't reviewed them. I don't know. You know what I mean. Okay. Carrying on. The defendant